Good morning, everyone. I just want to give you a few housekeeping tips. We will not be utilizing the chat. So please submit your questions using the QA feature at the bottom of your screen. Just to let you know, you will all receive an email from me, a follow-up email that will include a link to this recorded webinar, as well as a link to a PDF version of the presentation Erin is about to give. Thank you so much for joining us. Erin, I'm going to go ahead and let you get started.
Thank you so much. Let me just share my screen and we will get started.
We can see your screen.
Okay, great. Perfect. So good morning. Our focus this morning is on making sure the businesses have an understanding of what they need to know about both Connecticut FMLA and the Connecticut Paid Leave Act. We call this Hey, Do You Have a Minute? Because in our collective experience, that's usually what starts the conversation between an employee and an employer when the employee needs to take some time off. That knock on the door and, hey, can we talk? So we want to make sure you know what to do when that happens. My name is Erin Choquette. I am the General Counsel for the Paid Leave Authority, and I'm happy to be here with you today. We're going to jump right into the content so we have time for questions. As Amber mentioned, please put your questions in the Q&A function, not the chat. So we're going to talk a little bit about the Connecticut Paid Leave Program. Then we'll focus on understanding the differences between FMLA and Connecticut Paid Leave. And then we'll talk a little bit about how we'll be implementing the Connecticut Paid Leave Act and how employers will need to implement the Connecticut FMLA. We'll share some resources, and as I mentioned, we'll have time for Q&A. So please feel free to put those questions using that function. The Paid Leave Authority is a quasi-public agency. We were created by statute in 2019. Our board met for the first time about 2 years ago to the day, I think. And our purpose is to create a program so that individuals can take the time they need to care for themselves if they're sick or to care for a loved one without having to worry about suffering the consequences of lost income. So we want to make sure that paid family and medical leave benefits are accessible to employees, but we also want to empower employers, third-party administrators, healthcare providers, and all the others who participate in this program or in this process to make sure they understand their roles and to give them some helpful tools and techniques to use. At the authority, we have several hats. We are charged with outreach and engagement, which is one of the reasons why we do these webinars, to make sure that people understand the program. We had to set up the program from scratch since we were brand new. So the first year was really staffing, setting up the contributions, which we started with January of 2021, accepting contributions from employers, setting up the process for employers who wish to offer a private plan in lieu of having their employees participate in our program, and working very hard to get the claims up and running so we can start accepting claims in a couple of months. As I mentioned, it's been quite the whirlwind. Our CEO was hired in March. The rest of our staff came quickly thereafter. We have all of 20 people now, so we're very excited. Employer registration on our website started in November of 2020. So our website went live in August of 2020. Registration opened in November. Employers began deducting wages, the 0.5% contribution from wages in January. And those private plans that I mentioned, we started receiving applications for those in February. And we've just been going gangbusters since. Starting in December of 2021, in just a couple months, we will start accepting applications. We won't actually be able to issue any benefits until January per the statute, but we can start accepting applications early. So that's what we're getting ready for now. The threshold question for really any program is who's covered, who's part of this program? And the short answer is almost everybody working in Connecticut. So employers who have one or more people working in Connecticut are covered. This includes nonprofits. It also includes private sector employers with unionized workforces. Even if you don't participate in unemployment insurance, you do participate in the Connecticut Paid Leave Program. Sole proprietors and self-employed individuals. So basically independent contractors, are not required to participate, but they can choose to enroll if they want to. And if they choose to opt in, they are required by statute to stay in for 3 years at a minimum. There are some entities that are explicitly excluded from our statute. These are really entities that are also excluded from the Connecticut FMLA statute. So there's some parallel here. That includes the federal government, the state of Connecticut, except as to covered public employees, which I'll define in a minute. Municipalities and local or regional boards of education are also excluded unless they have covered public employees. And non-public elementary and secondary schools are excluded explicitly in our statute. There are also entities that are exempted from our program as a result of other laws. For example, railroad workers are covered under a separate federal law. Employees who work for governments of other states or employees of other sovereign nations, including Mashantucket and Mohegan Sun, the Pequots, are excluded. We don't have authority over employees of other sovereigns. There are a couple of tweaky little exceptions. These are employees who may work in Connecticut, but don't pay Connecticut income tax. So if you are someone who is engaged in interstate commerce, like an interstate truck driver who works in Connecticut but lives in another state, you don't pay any payroll taxes in Connecticut, and so you wouldn't pay into the Connecticut Paid Leave Program. This is just for those interstate commerce workers. Also, there's a rule with spouses of active duty military members who may have moved to Connecticut because their spouse is deployed here, but they continue to have residency in their home state and continue to pay taxes in their home state rather than where they're currently deployed. So those are two little exceptions. If you have employees who fit into either of these categories, you already know it because you're already not paying payroll taxes for them. So I promised to define covered public employees for you. These are non-unionized employees of the state of Connecticut. So managers, officials, legislators, judges. If you're a non-unionized employee of the state of Connecticut, you are covered, which means you do contribute and may apply for benefits. The unionized employees of the state may collectively bargain to be included. And with employees of municipalities and employees of local or regional boards of education, they're currently excluded, but if the unionized employee of that town or board collectively bargain to be included, then everybody, union and non-union, will come into the program. As I mentioned, sole proprietors and independent contractors, self-employed individuals, are not required to participate. So we get a lot of questions about, well, how do you define a sole proprietor or self-employed individual? The basic answer under our statute is that if you pay self-employment taxes as defined by the IRS, you are not an employee. So you can choose to enroll, and if you enroll, you would contribute 0.5% of your self-employment earnings. If you are a sole proprietor who also has employees, you have to register and remit contributions on behalf of those employees, whether or not you choose to enroll for yourself. Now, we know a lot of people may set up a business and may be the owner, but they set themselves up as an employee under their business. So they're receiving a W-2 from their business. If that's the case, you've set yourself up as an employee for purposes of Connecticut taxes and federal taxes. And so you're considered an employee under the Connecticut Paid Leave Program. I mentioned the employees contribute 0.5% of their wages. Their wages are calculated the same way you calculate wages for FICA. And that's because the contributions are limited by statute to the Social Security contribution limit. So once somebody hits that limit, they stop making contributions. It is entirely employee funded, but the employer has to handle the mechanics of the paychecks, right? So the employer is the one who deducts the contribution from the paychecks and remits those contributions to us on a quarterly basis with some minimal wage information. Hopefully you're all familiar with this process because we're 3 quarters in. You send that information to us, we validate it and deposit it right into the Paid Leave Trust. The Paid Leave Trust is actually managed by the Office of the State Treasurer, but it is not considered state funds. It is solely used for the purpose of administering the program and funding the benefits. It cannot be used for any other purpose in state government. All right, That's a little bit about the program. Let's make sure we all know what we're talking about when I use the words or letters FMLA and CTPL. State government uses a lot of acronyms, so it's good to always define our terms. Particularly when we're talking about something like FMLA, because that stands for two separate laws. The letters stand for Family and Medical Leave Act, and there is a federal FMLA and a Connecticut FMLA. Both laws allow eligible employees to take protected or job-protected time away from work for specific reasons. Both laws say that the leave is unpaid, but that the employer may adopt policies to permit or require the employees to use their or earned accruals while they're out, or to allow an employer to have some sort of other paid leave program. The federal FMLA hasn't changed since about 2008, although there are some discussions in Congress to update it. But we know that Connecticut FMLA is changing because the same law that created the Connecticut Paid Leave Program also created changes to Connecticut FMLA that will take effect on January 1st, 2022. Included in those changes are changes to eligibility, changes to the job protection, changes to the reasons for leave. So let's talk about that a little bit. Right now, and since the 90s, Connecticut FMLA has applied to employers with 75 or more employees. But as of January 1st, it will apply to employers with 1 or more employees. The eligibility will also change. Right now, an employee has to work at least 12 months for the employer and at least 1,000 hours in the 12 months before they ask to go out on leave. So they really only get job protection after they've been with you for at least a year. Under the new entitlement, there will be no longer an hours worked requirement, and job protection is available for leave after 3 months. So an employee could work for you for 3 months and a day and say, I need to take leave, and it will be job protected. The amount of leave changes as well. Up till now, it's been 16 weeks of leave in a 24-month period, with this entitlement for 26 weeks of leave in a 24-month period for military caregiver leave. In this January, it will be 12 weeks of leave in a 12-month period, except you'll have 26 weeks of leave for military caregiver, and there's an entitlement to an additional 2 weeks of leave for incapacitation during pregnancy. Finally, as I mentioned, FMLA is unpaid, but the law says that the employer may permit or require employees to use accrued time during their unpaid leave so that they receive income. That language is slightly tweaked, and it says the employer may permit or require the employees to use their accrued time off, but they can't require them to exhaust all of their accruals while they're out on FMLA. You have to allow your employees to hold up onto at least 2 weeks of their accruals so they can use them for other purposes. So that's FMLA. CTPL stands for Connecticut Paid Leave. So we use this to reference both the Connecticut Paid Leave Act as well as our program and the Connecticut Paid Leave Authority. So you'll see us refer to ourselves as CTPL or the authority. The Connecticut Paid Leave Act is a Connecticut law, and it creates a source of income replacement benefits for eligible employees who cannot work because of covered reasons. It does not provide for job protected leave. You might also see this referred to as PFML or paid family and medical leave. We've tried to use CTPL instead of PFML just to eliminate confusion because FMLA and PFML just look too similar. For both FMLA and for Connecticut paid leave, there are specific reasons that an employee can take leave and request benefits. First of those is for their own medical condition. So a person who needs to receive treatment or recover from their own serious health condition can take leave or receive benefits. The definition of serious health condition is defined. It's in the statute. You can find it on our website, but I just want to flag for you that it includes pregnancy. Pregnancy is considered a serious health condition, as is serving as an organ or bone marrow donor. You could also take leave to care for your family member who has a serious health condition. Then there's the happy reason, which is the bonding leave, to bond with your newborn baby or a newly placed adopted or foster child. And with foster care and adoption, You can take bonding leave to attend to certain pre-placement activities like going to court or traveling to be able to connect with a new child. As I mentioned, there's something called military caregiver leave. This is special leave that is to care for a family member who's been injured on active duty in the military. There's another military-related leave. Again, it's for the family member, not for the person in the military. But if you have an employee whose parent, spouse, or child has been deployed overseas or was received a call for overseas deployment, they can take time off to address specific issues associated with that deployment. And finally, Connecticut law has something called the Family Violence Leave Act. This law has been in effect since about 2010, and it says that employees, for employers of any size, are entitled to take up to 12 unpaid days off from work if they are directly experiencing family violence and need to go to court, to relocate, or to receive treatment or counseling. And employees who are taking that leave could receive income replacement benefits from the authority for those purposes as well. Let's just talk a little bit more about caregiver leave. As I mentioned, that's leave when your family member is sick. Now, federal law and the old Connecticut FMLA said you could take caregiver leave for your parent or spouse or your child who is under the age of 18, or a child who is 18 and over who has a disability as defined by the ADA, which causes that individual to be incapable of performing 3 or more activities of daily living. So it's a pretty high bar. Under the new Connecticut FMLA that takes effect in January, and under Connecticut Paid Leave Act, an employee could receive or take leave and receive benefits for their parent or spouse, their son or daughter of any age, a sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity whose close association to the employee shows as the equivalent of one of those family relationships. All right, so what does that mean? Well, basically it's a recognition that the Ozzie and Harriet family of the 50s is not really reflective of society today. Families come in all shapes and sizes, and there may be people who are as close as family to you, who play that role in your life, who do not have a blood relationship or a legal relationship. So in my family, for example, my great aunt really took the place of my grandmother, who had passed away when I was a baby. So we did her grocery shopping for her. When she got older, we did her laundry for her. She came to every event, every school concert, every birthday party. She was like a grandmother, right? You could also have someone who's your unmarried significant other. Connecticut law does not recognize common law marriage. So up till now, if you were not legally married to a person, you could not take FMLA for that person. You could not take leave to care for them when they were sick. But with this new related by affinity definition, that unmarried significant other, the Goldie Hawn and Kurt Russell relationship, that would count. So I think the thing to remember here is the employee has to explain to you how the person qualifies as a family member, and that person's doctor will have to say, yes, the employee is needed to help care for this person. So there is some protections against sort of picking somebody randomly out of the hat and say, oh yeah, I'm related to them. Oops, trying to move forward. Quick summary, this slide is really just for handy kind of stick up on the wall purposes. There's federal FMLA. As I said, that's not changing, at least not yet. And that requires an employee to be employed for at least 12 months and to have worked for 1,250 hours. It's always been a little bit more strict than Connecticut. Starting in January, Connecticut FMLA eligibility is simply to work for the employer for at least 3 months. For paid leave benefits, on the other hand, we don't really look at how long you've been working for any particular employer. Our statute says we have to look at how much the individual has earned from one or more employers. And so if the individual has earned at least $2,325 in their highest earning quarter, when we look at the first 4 of the most recently completed 5 quarters, they'll be eligible. And they also have to show that they're currently working in Connecticut, or if they're not working in Connecticut right now, they had been working for some point in the last 12 weeks. or they could be one of those sole proprietors or self-employed individuals who had opted to register with us. And again, just a quick summary of the leave entitlements. Federal FMLA is 12 weeks in a 12-month period, but you do get that 26 weeks for military caregiver leave. Connecticut FMLA is going to be 12 weeks in a 12-month period with the 26 weeks for military caregiver, those 12 days I mentioned for family violence, and the 2 extra weeks for incapacity during pregnancy. Now, if an employee is eligible for both federal FMLA and Connecticut FMLA, and the reason counts, then the federal and Connecticut FMLA will run concurrently, meaning they'll be running at the same time. The employee will pull from both entitlements. And then we've got Connecticut paid leave, which is 12 weeks in a 12-month period for all of those leave reasons that I mentioned, including military caregiver, with a note that only 12 days can be used for family violence because we're replacing those 12 unpaid days. And we do still have that 2 extra weeks for incapacity during pregnancy. Let me just take a quick second to look at the questions that came in. First, yes, presentations will be available after the webinar. And a great question, does Connecticut FMLA and Connecticut paid leave cover absences for parents-in-law? Yes, it does. The Connecticut DOL is in the process of updating its regulations, but we know from our communications with them that for Connecticut, in-laws are covered. So parents, child, sibling, grandparent, grandchild, all cover in-laws. All right, let's talk a little bit about implementing the Connecticut Paid Leave Act. You know, kind of the overview of what the rules are for when the leave may be eligible for income replacement benefits. But let's talk about kind of the responsibilities and how it all works. For the Connecticut Paid Leave Act, we really have 2 separate parts. The first is contributions, and the second is claims. So for contributions, the employee's responsibility is to contribute 0.5% of their wages. The employer, we need you to register with CTPL on our website, ctpleave.org. That enables you to create an account so that you can remit those 0.5% deductions that you've been taking from your employee's wages to CTPL with some minimal required backup information. If you use a third-party administrator, a payroll provider, maybe it's your tax or accountant who handles your payroll for you, they could set up the remittal process for you, but we still want you to register so we know who you are and we can get in touch with you if we've got questions, particularly as we get into the claims world. On the contribution side, the authority receives those contributions, we process the over and underpayments that occur, and starting next year, we will be imposing penalties for non-compliance. We made the decision this year not to impose penalties because it's the beginning. No, there's a learning curve, but there will be penalties starting next year for employers who don't register and remit those contributions. Now, the Connecticut Department of Labor does not have a particularly active role in connection with contributions, but they do have their general wage and hour authority, which relates to when employers can take deductions from employees' paychecks without employees agreeing to it. And so the Connecticut Department of Labor has used that authority to create a kind of universal catch-up period, which just ended on September 31st, for employers to try to catch up if they didn't take their deductions starting in January. If you're in the boat of having your employees owe deductions from January, but you didn't start taking them in January, you have 2 choices. One is you can pay those contributions yourself as the employer, but there are some tax consequences associated with that because that's a benefit to your employees. Or you can talk to the Connecticut Department of Labor about getting individualized approval to take additional deductions to catch up so that you're caught up by the end of the year. The other half of our responsibilities relates to the claims. So let's talk about what everyone does with claims. The worker has to submit the application. It's up to the worker to tell us that they need the income replacement benefits. They can do that by going to ctpleave.org and creating an account, or by calling our third-party administrator. We've contracted with AFLAC, so they will have a 1-800 number that people can call. There'll also be an email address and a fax number, as well as the regular postal address. So there's multiple ways to create the account. When the worker applies, they'll have to provide supporting documentation. And then when they go out on leave, they'll have to tell us that they're going out so that we can start paying the benefits. And they have to tell us if they're receiving other sources of income. By law, the worker is required to notify their employer when they apply to us for CTPL leave benefits. Also, we're going to ask the employer to give you, the employees, to give you, the employers, something called an employment verification form. That enables us to verify employment with you, the employer, get some basic information about the employee's schedule and wages, and if they have other income coming in. So we'll need the employer to submit that form. It's a page and a half. We may need you to validate absences and other sources of money. If you have paid time off policies, and you really should, you need to tell your employees what they are. Are you going to require them to use their accruals? Do you have a short-term disability policy that's available to your employees? You need to let them know what that is. And as a lawyer, it's sort of my obligation to remind everyone, you can't discriminate or retaliate against a worker because they file a CTPL claim. In terms of claims, the Paid Leave Authority with our administrator, AFLAC, will process the claims. So determine eligibility, review the documentation, calculate the benefits, monitor the leave requests. Again, we're not providing the leave, we have to monitor the absences to make sure we're not paying people when they're back to work. If we deny claims, we do give the employees an opportunity to request reconsideration. And if we become aware of fraud or suspect fraud, we will investigate that and impose penalties as appropriate. The Connecticut Department of Labor is charged with the responsibility of hearing appeals relating to denials of claims or any penalties we impose. So what does this look like? Well, the worker submits the claim. So they can call AFLAC, they can go to ctpleave.org and create their account, they can send in a letter, they can fax something. There is an application checklist that they'll go through, and that'll identify the supporting documentation. The documents depend really on the reason for leave. What we need for military caregiver is slightly different than what we need for bonding. But the employee has to tell us what's the reason, how long are they going to be out, is it going to be on a block leave, are they going to be on a reduced schedule, so that we can make sure we're paying for when they're not working. And again, if they have any other jobs or other sources of income. AFLAC will determine eligibility, and we're using a data feed from DOL as well as other documentation as necessary to validate that 23-25 in their highest earning quarter. And we have to make sure that they work for a covered worker, whether they're enrolled. If they're not eligible, we'll notify them right away. If they are eligible, we'll make sure they understand the documentation they need to provide and review that documentation, letting them know if anything's missing. And if the documentation does not support a claim, we'll deny it, but leave them an opportunity to request reconsideration. If it does support a claim, we'll calculate the benefits and issue those benefit payments. We're using electronic transfer or stored value cards, so debit cards. Our plan is to issue the benefits every Tuesday. We say it's 2 weeks in arrears. Technically, it's about 9 to 10 days in arrears. So, for example, the benefits for the first week of January, the week that ends on January 8th, will be issued on Tuesday, January 18th. This extra week just gives us time to make sure we know that the employee is out, still out, that there aren't any other income coming in. But we do require the employee to notify us if there are any changes to their circumstances after they apply. The benefit calculation is set in the statute, and it depends on how much the worker earns. If they earn less than or equal to the minimum wage times 40, their benefit will be 95%. If they earn more than the minimum wage times 40, the benefit is 95% of 40 times the Connecticut minimum wage, plus 60% of the difference between their earnings and that Connecticut minimum wage times 40. However, in all circumstances, the benefit is capped at 60 times Connecticut minimum wage. So on this next slide, we just sort of show it mathematically. If we're talking about minimum wage being $13 an hour, 40 times Connecticut minimum wage is $520 a week. A person who earns that amount or less would receive 95%. So In this scenario, the person's going to receive $494 in benefits. Their colleague earns a little bit more than they do. They earn $13.50 an hour. So 95% of 40 times the Connecticut minimum wage plus 60% of the difference between what they earn and the Connecticut 40 times Connecticut minimum wage results in an extra $12 a week for worker B. As he said, someone earns a great deal more, the money is still capped at 60 times the Connecticut minimum wage. Okay, we get a lot of questions about the intersection of employer-provided PTO and CTPL leave benefits, because under FMLA, the employer may require or permit the worker to use any of their sick or other PTO, with that caveat that they have to let them hold on to 2 weeks. And our statute says that an employee could receive benefits from both the CTPL Leave Authority and their employer at the same time, as long as the total amount does not exceed 100% of the worker's regular wages. So, first thing, let me say, if you offer short-term disability, you need to look at your policy. Most short-term disability policies say that they are the payer of last resort, which means the employee has to use all the employer-provided PTO and all of CTPL benefits before they can tap into that insurance plan. So check out your policies. But if we're just talking about employer-provided PTO, that's really up to you to set your policy, right? If you don't provide PTO to your employees, or the employee has exhausted all their PTO before they even go out on leave, then the employee has not eligible to receive any employer-provided paid time off. They'll start receiving paid leave benefits from us as of the first day they go out on leave. On the other hand, if the worker is receiving employer-provided PTO that is equal to their regular pay for the full amount of time the worker's out on leave, they don't need any income replacement benefits from us. So they'll use up their employer-provided PTO, and it won't tap into the 12 weeks entitlement from us. If you are an employer who is worried about your employees stacking their leaves, so using one entitlement and then another consecutively as opposed to simultaneously, you should give serious consideration to adopting a policy that says you want your employees to use their employer-provided PTO first, because at least to the extent allowed by CTFMLA, because employer-provided PTO does come with some job protection. So if you're worried about how much job protected leave your employees have, you probably want them to use that employer-provided accruals while they're also out on Connecticut FMLA. But that is a decision for each employer to make. We just need to know what you're doing so we can adapt accordingly. Lots of times employees have a couple of weeks of PTO, but not enough to cover their full amount of leave. So if you have a worker who receives employer-provided PTO that is equal to their regular wages, but it only covers a couple weeks, not the full amount of time they're out on leave, they will get CTPL leave benefits, but the payments won't start until the worker stops receiving the employer-provided PTO. So their leave might start on February 1st, but they've got accruals that cover them until February 15th. So they'll start getting benefits from us on the 16th. Some employers have policies that say, we'll cover your absence at 60% of your regular salary. If that's the case, the worker would get their 60% salary from their employer, and they'd get their paid leave benefits from the authority, and they would run simultaneously, both beginning as of the date the worker starts the leave. But we would reduce our benefit to make sure the total amount does not exceed 100% of the regular wage, which is why we need information from you, the employer, on that employer verification form. So basically, if an employee or the employer, for that matter, is trying to figure out what the entitlements are, first we need to know what the employer's policy is and whether there are any rules. Some employers say you can use your sick time, but only for yourself, not for caregiver. And we need to know if there's a short-term disability policy and what that says. And then once we have those figured out, it just slot into one of those 4 categories I just described. Take a second to look at questions. All right, I'm going to hold these questions to the end because I think I've talked about some of them. All right, so we've talked about Connecticut paid leave, which is really the employee and the Connecticut Paid Leave Authority with AFLAC, and the employer has sort of a supporting role. With Connecticut FMLA, the employer has a major role, so it's important to understand your roles there. The employee has to tell the employer they need time off from work, and they have to provide the employer with an application if the employer requires one, and documentation. And they should comply with your attendance and call-in policies. So you need to have some policies in place. Do you have an attendance policy? Do you have a leave policy? Do you have policies about PTO? There are posters that the federal FMLA requires. If you have 50 or more employees, you should be posting that. So get that up. Your employees go to you for the leave, so it would be up to you to process the leave request, determine eligibility, monitor the usage, manage the employee's return to work. And of course, as always, don't discriminate or retaliate because someone is using their FMLA rights. Connecticut Paid Leave Authority does not actually have any official responsibilities relating to FMLA, but we do provide this information when we talk about CTPL because we've learned it's really difficult to explain the differences between CTPL and FMLA without talking about FMLA. The agency that does have responsibility over FMLA is the Connecticut Department of Labor. As I mentioned, they are responsible for promulgating regulations, and they are in the process of updating those regulations to match the new law and providing guidance to workers and employers. And their big role is investigating complaints regarding denials of FMLA as well as appeals. And those appeals could also relate to complaints about discrimination, retaliation, as well as failure to provide FMLA. So the process for FMLA is going to look very similar to the process I outlined for CTPL, but it's the worker and the employer. So they can use the same documents. We will accept, the MedCert that the employee gave to their employer. If you have a special form you want them to use, if it has the same information as our form, we'll accept yours. That's fine. We don't want to make extra work for people. First, it starts off with the employer, the worker notifying the employer they need time off from work. They don't need to use the word FMLA or say this is a family and medical leave. They need to give you enough information for you to say, they have their own serious health condition, or they're taking leave to care for mom who's sick, or to bond with a new baby. This sounds like FMLA. They're supposed to tell you 30 days in advance if the need for leave is foreseeable, or if it's not foreseeable, as soon as practicable. That doesn't mean they call you from the ambulance, but it does mean they should call you and let you know within the day or so. The employer determines if the worker is eligible for CTFMLA. And that asterisk is also for any other leave rights, like federal FMLA, if you're covered by that. And you notify the worker if they need to provide you with any additional documents. You have 5 business days to notify the worker if they're eligible and to provide something called the Notice of Rights and Responsibilities. Now, the Federal Department of Labor has a Notice of Rights and Responsibilities that employers can use. And the Connecticut Department of Labor is in the process of creating one that relates to Connecticut law. So there should be some forms that will become available to you very soon. So you need to use that to tell the worker what their rights are and what their responsibilities are. This is not leave approval. This is just the ticket to get in the door, right? You are eligible. You have worked your 3 months. That's what that is. The worker has to give you documentation, whether it's the medical certification or the adoption records or the military records, depending on the reason for leave. And you have to give them at least 15 calendar days to provide that documentation. If the worker can't get you the documentation within 15 calendar days, it's up to them to tell you that and to ask for more time. And the law, both Connecticut and federal law, says you should give them more time. Usually it's another 15 days. Then you get that documentation in, and you have 5 business days to determine if the leave is covered. Does the documentation support that they have a serious health condition or that they're bonding, whatever? Again, Connecticut FMLA and any other leave entitlement. When you tell them that they're approved, you need to tell them if they're going to be required to use their accruals, if you need them to report in while they're out, if they need to provide a fitness for duty before they come back. You also need to tell them if you're denying it or if the information is insufficient. the information is insufficient, you have to give them an opportunity to cure it, and you have to give them at least 7 days to cure. So in the happy path, the employee knows that this is all happening and they've done all of this work, so you can get this all worked out before they are absent. So now they actually have to go out on leave. They have to tell you, yep, my leave starts today, or I'm in labor. I know I wasn't expecting to be in labor until next week, but baby's coming today. They have to let you know they're out. And this is when they have to say, yeah, this is my FMLA. They can't just call in sick. You need to track their leave usage. And again, if it's Connecticut and federal, you want to track under both entitlements so you know how much they're using. Then this whole thing is job protected leave, which means the employee gets the right to go back to the same job under the same terms and conditions as when they went out on leave. There are those ads like about Bob from Account Temps who does such a great job. They're so much better than the original employee. Well, you can't keep Bob from Account Temps just because they think they did a better job than your original employee. The original employee has the right to come back to their job. And when they come back, you can't say, no, you have to be 100%, no restrictions. Employers have to consider if an employee has rights under the Americans with Disabilities Act or the Connecticut Fair Employment Practices Act, which say that an individual with a disability has a right to accommodations to help them perform the essential functions of their job. So maybe they need to come back on a reduced schedule. Maybe they need assistance with lifting, whatever. You have to consider those obligations. So just remind you that there are these other laws that exist that play into this process. We know FMLA is not 100% easy. So let's talk about that. Let's just acknowledge it and confront it. The very first thing is you have to manage the worker's absences. The best way to do that is to have attendance and call-in policies and actually enforce them. And it's also important to make sure your supervisors and managers know that they have to track those employees' absences and let your director of operations or your HR know when someone's out. Another big issue is med-certs. You have a right to a complete and sufficient med-cert. You don't have to accept something. You don't have to accept a scribbled doctor's note. There are med-cert forms both on the Connecticut DOL page and the federal DOL page. There's also, you can use our med-cert if you like, but you want to get a good one. You want to make sure that it's complete and sufficient. Now, employees who take intermittent leave, this is leave where they've got one leave reason, but they're out multiple times, and sometimes it's unforeseen. Perhaps they have Crohn's syndrome or Crohn's disease or Lyme disease or something where it's they have flare-ups and they don't always know when the flare-up is going to happen. You need to work with the employee. You can ask the employee to have the doctor indicate based on their medical condition and the doctor's experience. We estimate that they'll have X number of flare-ups per month, and each flare-up may last X number of hours. So that can help you kind of manage and understand likely absences. If you have workers who work overtime, you have to include their overtime when you consider their work week, which goes into how much leave entitlements they have. But if they can't work overtime because of their FMLA qualifying reason, you would count those hours against their entitlement. So it goes both ways. And again, you have to think about the other laws, Connecticut FMLA, federal FMLA, Americans with Disabilities Act, Pregnancy Disability Act, Workers' Comp. One final note with this, you may have workers who say, don't call this FMLA. I'll just use my sick time. Don't fall for that. It's a trap for you, and it's really a trap for the employee as well. In all circumstances, it's the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA leave. So this protects you, the employer, because it shows that you're giving the employee their entitlements. You don't want to be sort of nice to the employee and then have the employee turn around and say you denied them their FMLA rights. It also helps you because it helps count down those 12 weeks. It helps the employee because the employee gets the job protection that they're entitled to, and they may not understand that that's what it gives them. Just a quick reminder, I think I hit all of these. I didn't talk about Pregnancy Disability Act. Pregnancy Disability Act is a federal law which says you can't discriminate against individuals because they're pregnant. It also recognizes that leave may be a reasonable accommodation. You can't force an employee who's pregnant to take leave, but if they ask for it, it might be reasonable. That's it. Other thing I want to mention on this slide is that workers' comp. So an employee who's receiving workers' comp benefits cannot get money under the Connecticut Paid Leave Act. It's an absolute bar. So you get either, if it's a workers' comp covered injury, they get their workers' comp benefits, and that's what they get. If it's not a comp covered injury, they can apply to us for benefits. Promised you some additional resources. If you go to ctpleave.org, we have an employer toolkit. We've actually just updated it. That includes posters, mailers, rack cards, fact sheets, all sorts of information available to you for yourself and to give to your employees so that you're not put in the position of trying to explain to your employees what their entitlements are. If you go to ConnecticutPaidLeave.org, you will see FAQs. You'll also see videos, the new HR toolkit, the new business toolkit. There's a small business landing page. There's a new page that talks about the claim process. So there's all sorts of information. But if you still have questions, you could submit those questions to us through the Contact Us button on our website. So you click on Contact Us, you tell us what your question is, and you'll get a response. If you'd rather get a phone call, we'll call you back. We do not have a phone number that you can call in. But frankly, it costs far more than we can afford to staff a call center. And our goal is to operate this program as efficiently as possible and make sure that the majority of money goes to the benefits. So Contact Us is the way we've addressed that. But again, if you want a phone call back, they will call you back. If today's presentation leaves you asking for more, we've got all sorts of videos on our YouTube channel, so you can check us out there as well. Like us, put ConnecticutPaidLeave.org in your favorites, and as I said, check back frequently because we're really updating that space every few weeks at this point. All right, I'm going to stop sharing my screen and go back to the Q&As, see what I missed. So first question, if the employer pays 100% PTO for 2 weeks, would the employee be only entitled to 10 weeks of CTPL? No. So the employer pays the first 2 weeks, and then CTPL will kick in on week 3. If the employee doesn't need, another 12 weeks of leave, they'll still have time under CTPL. I'm not sure I explained that well. I'm going to say that again. The employee would only use CTPL when they're getting benefits from us. So if they're not getting benefits from us, it does not reduce their entitlement. Okay, we get this question all the time. If the employee has a baby in December of 2021, could they get benefits in January? Yes. So if they have the baby in December of 2021, if they go out for surgery in December of 2021, if the absence starts before January 1st, 2022, we cannot give any benefits for any absences associated with the 2021 time off. But if they're still out in 2022, then yes, they could apply to us for benefits. And as I mentioned, we'll start accepting claims as of December 1st. So if you know employees who are going to be in that situation, they should submit their claims to us early so that they can start getting their benefits earlier. So question comes in, does the employee go to CTPL first or before going to their employer for FMLA or vice versa? Well, if they come to us first, we are going to make sure that they notify you that they came to us, and we're going to notify you that they came to us. So you won't be surprised that they came to us. But from a practical matter, I think employees will tend to go to their employer first because they have that day-to-day relationship with the employer. And so the expectation would be, hey, I need to take leave. I need to not be at work, and I need to tell you why. And then, oh yeah, I need some money while I'm not at work. Then they come to the authority. So what is the expected time frame from application to processing to receipt of income? Well, if everything is being done, if it's a foreseeable leave, so the employee comes to paid leave authority in advance, they have to notify us. We will notify them of eligibility right away. Then they have to give us their documentation. If they give us their documentation right away, we have 5 business days to approve the entitlement, and then we'll start paying benefits, as I said, that 10 days in arrears. If the employee takes a long time in getting us the documentation, then that's the part we can't control. But as soon as we get the complete and sufficient documentation, we'll have those 5 business days to approve it or deny it, and then we'll pay the benefits. So it really is in the employee's best interest to notify us as soon as possible, just like it's in their best interest to notify the employer as soon as possible when they're going out. So Aflac, we have a staff. One of the reasons we entered into a contract with Aflac is because they're obviously a well-established, very professional, very well-respected resource that is already staffed up. So we didn't have to start from scratch. And they are hiring claims people and call center people, because Aflac will have a call center. And so we believe we have more than enough staff to cover the anticipated claims, and they can adjust to make sure it works. So question, how long does CTPL have to make the decision? As I mentioned, it's 5 business days. So what happens to Bob? Bob from Account Temps, who is substituting for the employee who is out on leave. Is Bob getting fired? Who would go on working? People want stability. Yeah, we recognize this. This is, if you're a larger employer and you've been dealing with FMLA for years, this is something you've already probably been used to. But for smaller employers, it's a little bit tricky. So if you have to hire someone to cover while you have an employee who's out, you might hire from a temp agency, in which case, Bob from Account Temps knows it's a temp job and they'll just take on another assignment. Maybe you do some cross training if that's something that's feasible for your business and your agency, in your industry, so that when someone goes out, you don't necessarily need to hire new people. If you do, in fact, need to hire somebody else to cover while someone's out on a long-term absence, and then you need to let that new person go when the original person comes back, the law the Connecticut FMLA law specifically says that the employer will not be charged for the unemployment, so they won't get a ding on their unemployment insurance for that. I can tell you that we have partnered with the Connecticut Small Business Council to sort of help employers deal with some of those operational issues. So Connecticut Small Business Council is doing some webinars that are really geared to focusing on those operational issues, not the law that we're talking about, kind of, okay, that's the law, how does it affect us? So please be on the lookout for those webinars. Question, can an employee take a half a day to take leave? Say they need to take doctor's appointments. So yes, so leave can be taken and benefits can be provided on a block leave, which is one single leave for several days or several weeks. An intermittent leave, which is small bits of time for the same leave reason. So physical therapy is a great example, or other doctor's appointments. So the employee knows that they need to do caregiver leave because they need to take their mom to her chemotherapy appointments. And so the employee is only out for an hour in the morning and an hour in the afternoon, drop off and pick up, but that time is covered. Or as I mentioned, it could be that they have a condition where they have flare-ups. And so they go along, they're great until they have a flare-up and then they're out for 3 days. Or you could have reduced schedule. Reduced schedule is, that you're pretty much sure what your schedule is going to be, but you can only work part-time. You have to work Monday, Tuesday, Wednesday, because Thursday's chemo day and Friday's recovery from chemo day. Or you can work 5 days a week, but you have to leave at 3 o'clock every day instead of 5 o'clock. So that would be reduced schedule. All 3 leave types are covered under FMLA, and if your person's out for any of those, they could get income replacement for their absences. So clarify about the length of leave when someone is out. This is really an FMLA question, because as I said, CTP leave, no one gets any CTP leave until January 1st. So even if they went out in December, their CTP leave would start in January, and they get 12 weeks starting off when we start the benefit. But for FMLA, we've got this funky, it used to be 24 or 16 weeks in a 24-month period, and now it's 12 weeks in a 12-month period. So Department of Labor has issued a guidance. You can find it on their website. If you go to ct.gov, and type in Department of Labor, and then when you're on their website, type in FMLA, you'll see this notice. And basically they say, no one should get more than 12 weeks of leave in 2022. So if a person took leave in 2021, thinking it was going to be 16 weeks in a 12-month period, you can subtract some of that 2021 leave time to make sure that they don't get a windfall in 2022. I'll be straightforward. Their guidance is really detailed, and they give a lot of examples, but you have to read it a couple of times. So I don't really want to summarize it here and tell you the wrong thing. I'm just going to tell you to go to their website, CTDOL at ct.gov/DOL, and look it up so that I don't mislead you on what their guidance is. But also be prepared to read it a couple of times just to make sure you've got all the nuances. All right, it is 8:57. It does not look like any additional questions have come in. I think I've answered everything that's come in so far. Again, if you registered, which you probably did, because that's how you got onto the Zooms, you will be getting a copy of the presentation and the video, or you go to ctpleave.org, click on our events calendar, click on the day, and once we get the video back from Zoom, we will upload the video to the day so you can access it that way, or you can find us on YouTube. So there's many ways if you want to check this out again. Looks like we have one more question. Oh, got a thank you. Well, thank you very much. We appreciate your time and attention this morning. Please check us out, ctpleave.org. Tell your friends. Make sure that you are taking the time now to get prepared for January. If you don't have attendance policies, if you don't have an FMLA policy, this is the time to really get that up and running so that when the law changes in January, you will be prepared. It's the best way to go. And I hope that everyone has a lovely afternoon. I'm going to thank you very much. Amber, should we turn off the recording? All right. I'm going to go ahead and turn off the recording and say thank you and have a good day. Bye.